Well, good evening. Welcome, everyone. My name is Greg Brandes. I'm the Dean of St. Francis School of Law. And what a pleasure to welcome all of you here this evening to talk about the Supreme Court. No, it's a subject that's been very much on people's minds, and it always is. But we're here to talk about the cases tonight. So we'll be talking quite a lot about the 2018-2019 term of the Supreme Court of the United States, and talking primarily about some of the cases that are taking place during that term. And so we're going to do this a little differently tonight than perhaps you might expect, but I think it'll be a lot of fun. I think you'll really enjoy it. A couple of administrative reminders before we get started on the content. One is that I'll be routinely muting everybody as they come into the room just to cut down on background noise. But as you speak, if you are making a comment or asking a question, feel free to turn on your microphone and your video for that purpose. Glad to have it, just to control the stuff otherwise. The second thing is we are recording tonight, archiving it for those who couldn't be with us. So again, if you speak, as a reminder, that's a consent to being recorded in this context. All right, well, let's dive right in. Here's what we're going to do tonight. Let me get us over to our set of slides. And you now should be seeing, I hope you can see anyway, our first slide there about the new court and new term. What we're going to do tonight is you kind of have two choices when you're talking about the Supreme Court. You can kind of talk about the cases and try to handicap how they're going to turn out, and try to do that across, say, a broad selection of cases. Or you can dig a little deeper into a few cases. And tonight we're going to dig deep into a few of the more interesting cases that the court has in front of it, and a couple of them that have already been argued, as a matter of fact, by the court. So tonight, in fact, you get to be the court in respect to these cases. And there's no confirmation hearings, there's no background checks, none of that. The only qualification for being the court in our session tonight is the ability to log into the website that you see on your screen right now. So if you could open another browser window somewhere and log in to the website that you have on the screen, then you're appointed to the court tonight to decide these cases. We'll delve into them and kind of lay out some of the facts, certainly, and some of the issues. We'll also talk about some of the legal arguments that were made by the parties. And then it'll be up to you to decide which way you think they should go. We'll try and have a little bit of fun with what you think the policy ought to be in these cases, and that's probably what we'll spend the majority of our time talking about during our session tonight. Because Supreme Court justices, as much as they're obliged to follow the law, they also find themselves in a position of having to make policy decisions about how the law should be, as we well know. And so that'll be part of your job tonight, to tell us how the law should be, in as much as we'll get into some of the law that's involved in these cases, but we'll also want to take a look at where it ought to be as we work our way through them. Now, Supreme Court uses some rules for making decisions, and you may or may not have ever seen the so-called Ashwander rules in connection with studying this law, or maybe you never studied this law. So here are just some of the decision-making rules that the Supreme Court uses. By the way, again, if you just joined us, try logging into the site you see below, and at the moment you should just be seeing something that says that the survey will start, or the poll will start shortly, and it will as soon as we get through one of our first cases. Well, the court will not anticipate questions of constitutional law. So in other words, only when it's necessary to actually decide something is or is not constitutional will the court actually make a decision on that. The court won't formulate rules of law broader than are necessary to decide the facts in front of it. Now, this, of course, is, like many of these rules, something that in reading cases we would many times say, we've seen that violated a lot. And of course that's true. We've seen that kind of thing happen with our Supreme Court frequently over the years. But these rules laid down by Justice Brandeis in 1936 are supposed to guide the court and are still considered important decision-making processes for the court. The third one here is the court won't pass on a constitutional question unless there is somebody present on the ground upon which the case might be disposed of. There has to be some basis for actually disposing of the case. Even though it's properly presented by the record, the court won't decide it unless it has to. And then, of course, the court won't pass on the validity of a statute unless somebody is actually alleging that they've been harmed by it or injured by its operation. So you might, as you are the court tonight, keep in mind the Ashwander rules. As you look at the decisions we'll ask you to make, you might think about which of these might apply to some of the cases that we'll talk about during the session tonight. Once again, as a reminder, everybody, if you log in, you'll be able to answer our questions about these cases a little bit later as we get into those questions. All right, one last thing before we go, and that's our docket for the day. So the three cases that we'll delve into.
Miranda has joined the meeting.
Today. By the way, welcome to all of our folks who've just joined us. Please do, again, try to log into the website that you see at the bottom of the screen there, because you can participate on our court today. If you can't, for any reason, by the way, you can still participate by engaging in our chat function right inside the WebEx meeting that we're conducting tonight. So feel free to do that as well at any time. Okay. Well, these are our three cases tonight. We have a case in maritime products liability. Now, it's not so specifically maritime law that it isn't useful to us to think about and understand. In other words, you don't have to be an expert in maritime law to understand this case, but it does touch on principles that go outside the general common law, and is therefore a little bit more interesting than some of the basic cases. We also have a case of the scope of regulatory decision making, and that's the Weyerhaeuser versus United States Fish and Wildlife Service case. This is whether or not really the Fish and Wildlife Service properly classified some habitat, and of course the impact of that is essentially a taking under the Commerce Clause and Takings Clause. And then lastly, a case that touches probably all of us, or not all of us, but at least quite a lot of us, and that is the Apple Incorporated versus Pepper case. And this concerns the Apple App Store and allegations of antitrust in relation to Apple's activities in sponsoring and running the Apple App Store. Obviously, we have a body of antitrust law concerning price, and there's some interesting allegations in the case concerning how Apple's control of the App Store resulted in unfavorable pricing. And we'll get into that one toward the end of our day today. So three cases in depth today, and we'll see some of the legal arguments and how they were framed, and then we'll give you a chance to decide, and you can make your ruling on those cases. All right. Well, let's turn to our very first case of the evening, and it concerns some of our men in uniform, or men and women in uniform. And this is a case where the plaintiffs are the widows of some U.S. Navy sailors who served on some ships. One officer served in the 50s and 60s. Another officer served in the 70s and 80s, or sailors. I'm not positive they're officers. I think one was, one wasn't. During that 4-decade span, at a time when the United States Navy used a fair amount of asbestos in a variety of different settings within the ships, and mostly for insulation, but also for some other uses that the cases get into. These cases, however, were not brought against manufacturers of asbestos. They weren't brought against people who even installed asbestos. They were brought against people who manufactured components that were installed and to which asbestos parts were added later. Now, there's some complication of some parts of the machines that were sold containing some asbestos pieces, but in the main, these were so-called bare metal components, meaning they didn't contain the product that was actually hazardous to these individuals. In fact, most of the materials that were installed many years before these particular servicemen were actually serving on the ships, or they were harmed, allegedly harmed anyway, by the inhalation of asbestos in the maintenance. It was primarily in the maintenance processes of these machines that these sailors were involved in. And of course, they died of cancer and asbestosis, and certainly a difficult and terrible thing. But the question is, who's responsible? That's what the case really is interested in. And so the issue that was certified by the court on the right-hand side there is whether products liability defendants can be held liable under maritime law for injuries caused by products they did not make, did not sell, and did not distribute. Because the pieces at issue that actually harmed these particular sailors were parts that were not sold by these manufacturers. Now, the manufacturers in question are some big companies and some smaller companies. Some companies like Westinghouse, were involved, as well as the successor companies to these large companies. Ingersoll Rand, which produced some compressors that were involved in the cases. So some big companies and then also some small companies that made particular components were the original defendants in the case, and now in this case they are the petitioners. And the procedural posture of the case is interesting. We'll get to it in a little bit more detail as we go along, but of course all the cases come to the court in a particular way, and that does affect in a way the decision making and the outcome on the cases. So let's take a look at some of the oral arguments that were made. This case was actually argued just recently, October 10. And if you haven't ever, I recommend that you check out a site called Oyez, that's O-Y-E-Z, in which you can listen to and watch the transcripts of Supreme Court arguments. It's always instructive on the legal issues that are involved, but for those of us who are interested in the law and those of us who are lawyers or prospective lawyers, really find it interesting to see the way the arguments were prepared and presented, the questions that were asked by the justices. They really give you a sense of what the justices find interesting about the particular case. And so I tried to pick a couple of them where there were already arguments that you could go listen to if you want to. And all you do is go to that site, OA, and look up the name of the case, and you'll be able to be linked into the oral argument along with some other information about the cases. So the petitioners here were the manufacturers. They were the ones who were bringing the case to the Supreme Court. And the petitioners' argument began with the core sense that these petitioners were not responsible to warn of something that they didn't install, they didn't purchase, they didn't design. So begins right out with Mr. Chief Justice, and may it please the court, the traditional opening to a Supreme Court argument. Describes the circumstance on the warning, gets into the legal position of the well-established tort principle that manufacturers are not liable for injuries caused by third-party goods, and then gets stopped by a question from Justice Ginsburg. Now, I did not pursue include the entire argument for you here. I just tried to pull a snippet or two that contains some of the core principles that were made by the parties. But it's really quite interesting when you listen to Supreme Court arguments to see how quickly these very experienced lawyers who've prepared the case significantly get interrupted and go off at a different track. This one, I think, will leave most of you feeling as though you might actually be able to do this because the arguments that were made are actually pretty simple arguments, and the questions that were asked by the justices, in the main, were not tough searching questions about the law. They were questions about analogous products for the most part, things like flashlights and ashtrays. Well, you might find it interesting to spend a little bit of time listening to this one, even if the particular area is not your particular area of study or interest. Well, the respondent, of course, had an argument as well. And the respondent's argument is this is failure to warn, and there is a duty to do so. If you make a product and you know that in its ordinary use, the product is going to cause a harm, and you know that, you need to warn about it. And this is an argument sounding in basic tort principles that have been developing over the last 30 years in regard to negligence and the duty to warn. And we see now warnings everywhere, of course, in products, and that's where it's coming from. The obligation that if we know something can happen, then we should share that information with the people who might be affected by it and might be using it. So the Court of Appeals here, the argument says, quite explicitly limited its holding to situations in which you have a product that has a part, and that part is required for it to operate. See, there's an allegation here that these bare metal manufacturers created something that was really detached from the full machine, or the full machine that represents the ship that these things were installed in. And so right off the bat, the respondent, reacting to arguments made by the petitioner in the briefs, tried to blunt the argument that these folks didn't have anything to do with the asbestos that was actually installed, because that was installed, in fact, by the Navy or one of its contractors after creation of these products, sale of these products, installation of these products in the main, in most instances. It was maintenance of those products later, where the asbestos had, for example, turned to dust and was inhaled by the Navy sailors when they were working on the ship. That, of course, caused the harm here. And so the fundamental argument between the two parties is whether or not the manufacturer who didn't install that stuff is going to be responsible for it, because they knew that asbestos was being used in connection with it. And indeed they did, because they knew that in some cases there were seals and other things that were actually made of asbestos. And they also knew that these things would be installed in a setting where there would be insulation and other materials attached to it that would cause it to be surrounded by asbestos. So there was some knowledge that might be applied to generate that tort principle about knowledge. Now we'll take a look at snippets from the briefs of the parties as well. And I won't read these for you. I'll pause for just a second and let you read the petitioner and respondent side. Well, while you're still reading, a couple of thoughts. First, on the petitioner's side, the case came to the court through the mechanism of the appeal on a motion for summary judgment. District court granted the motion for summary judgment to the petitioners. The appellate court reversed, the Third Circuit reversed, and combined a couple of different cases that were the two plaintiffs, as we mentioned before, that actually now spans 4 decades of potential liability. And of course, the petitioners want the summary judgment to be the case. So based on the law, that's what summary judgment is, and all the undisputed facts, summary judgment says we win, because we, in fact, don't have a responsibility under the circumstances. And that's the petitioner's argument. The respondent's argument is really very simple, in saying that traditional principles of tort law would apply in the maritime context. And the traditional principle of tort law that's involved is this obligation to warn. And there's a little bit of interesting talk about the manuals in the cases, particularly both briefs address the question of the manual that accompanied the machine and what the manual said about working with these parts that actually had asbestos in them. And so, of course, the dispute about that, just to flesh it out for you a little bit, is there was no warning regarding asbestos in the manuals. The manuals described a procedure for things like replacing a gasket sealed between two things, and didn't mention anything about precautions to be taken. And of course, that was because the Navy told the manufacturers not to. or at least the manufacturers allege that the Navy told them not to put those kinds of warnings in the manuals. They didn't want the sailors distracted by those things in times of war. So, of course, some interesting puzzles there about whether or not the manufacturers had the opportunity. In fact, it's alleged that the manufacturers proposed to the Navy that they should include warnings sometime in the 1940s, and the Navy resisted that all the way up until they essentially eliminated the asbestos in the 1970s. So, time to discuss the case a little bit. Let's bring it back into the room, and let's answer any questions. Let's talk through what we see. One of the most important questions here is, why don't they just sue the Navy? Anybody? Why not the Navy?
Is there immunity for the Navy?
Yes, James, that's exactly right. The Navy's immune. So they have to go after the manufacturers. Now, some of you may also be familiar that asbestos has been the subject of litigation for decades and decades. And there are enormous pools of money that are set aside for the long term to compensate those who suffer from asbestosis. Why wouldn't the recovery from one of those pools be sufficient in a case like this? Any ideas?
They're probably claiming it happened in maritime and it's not, doesn't apply to that, you can't get it from that pool.
That's it, exactly, Frank. The notion, I think that was Frank, the notion is that the pools are limited to certain settings and certain manufacturers, right? And the particular parts that were involved here are not the kind of stuff. Mostly it was other types of insulation that are the subject of those pools. Johns Manville is one of the big manufacturers that made asbestos insulation for many years. And those kinds of pools were created for a different sort of injury prospect. So these plaintiffs sued almost 50 different manufacturers of different components of the ships that their spouses, now deceased, were working on. And the theory, of course, is that most of them, because they knew that asbestos was going to be used, would have a duty to warn. What do you think? Raul, you actually have a question there. Let me bring up the chat window for everybody there. Did the manufacturers specify the exact materials to be used with their parts? Well, Raul, if you don't mind my sharing that question, that's a great question for the group to discuss. And the answer, according to the briefs, once again, is that the Navy specified everything. Or at least that was the allegation of the petitioners that wasn't particularly disputed by the respondents in the case. So the Navy is the one who decided to use asbestos well after it was known that asbestos had these problems or had these potential problems. And they did so for national security or national defense reasons. Asbestos was the lightest, practical, most effective insulating material that wasn't subject to wear and tear on the high seas, a whole variety of other reasons why the Navy felt that it was the most important. And in fact, it saved something like 300 tons of weight by choosing that over some other kinds of materials. And weight, of course, matters in ships to a certain extent because you got to put can't carry something else with when you add the weight. So very interesting question. And the manufacturers in general alleged, at least, that they generally did not. Now, again, there's a little bit of a twist in the case concerning some gaskets and bearings and things that were part of the original machines that were replaced with other asbestos parts before these particular sailors were harmed. So there's a little bit of a nuance there as to the exact argument that's being made about which one. Of course, the respondent's argument is it's all one machine. And if you know that it's going to be incorporate this material and have the potential to cause that harm, then their argument, you have the obligation to warn.
I'm getting some Paul's graph emanations here on how distant the expectation should be. Because from petitioner's view, that installation could be made from any material. A change order could come from Navy saying, do this now. Somebody could discover something that was better, more economical, more effective, or safer. And that happens all the time. So I am having trouble with the reasonable expectation here.
Well, indeed, it could have been that they manufactured it without asbestos, and the Navy came along and put asbestos into it. Couldn't that also be the case?
I don't know what the sequence of events is on that either.
Well, in fact, it isn't the way it happened, but it certainly could have been that case. And that's the question. That's what makes it an interesting question from the policy standpoint that you on the court have to decide tonight. Should we extend that liability in those situations where a product many years later modified by somebody else, or do we say the manufacturer knew that this was going to happen because they were working with the Navy and building these complex machines, and in doing so, they knew that asbestos was going to be used, and so didn't they have some kind of duty? And if they didn't discharge that duty, were they therefore not negligent? And if they were negligent, aren't they responsible for the harm caused to these individuals? So it is very much a foreseeability question with respect to the manufacture of those products and how far that foreseeability test should actually be extended.
You know, I used to work with procurement for the military, for the Air Force, not the Navy, but you know, depends on how these contracts are done also. If you are just, if the military comes to you and says, hey, build me some batteries, and you build a battery, and then somebody puts it in a case that's, you know, surrounded with asbestos, number one, it's not clear you would even know that, and then, you know, so it kind of depends on how the contracts are done. In other cases, the military goes and says, build me a whole, you know, clock, which includes the battery, and, you know, does the battery sub-manufacturer, are they responsible, or is it the guy that builds the whole thing? So if they built their product and somebody else built the, you know, the asbestos interface to it, you know, how would they, did they know, would they know, and is it really their responsibility, or is it the person who built the gasket's responsibility? So I guess that we...
Let's say, oh, sorry, let me interrupt.
But yes, but it depends on what the situation is. If they just built a box and somebody else, the government procured, you know, gaskets from someone else, and this guy had no idea what these gaskets were, then I would have a hard time holding him responsible. If, on the other hand, you know, his box required gaskets that were asbestos only, then, you know, then maybe he is. So it kind of depends.
Yeah, so let's limit it a little bit. The case, the question that was actually certified by the court to be the question in the case goes to this question of bare metal. So in other words, let's just focus on products that did not have asbestos components as a part of them, as part of what was delivered. Now, I can answer a little bit from reading the case about the contracting. It's true that they knew that after this stuff was delivered, when the Navy installed it, they knew the Navy was going to, or some third party, was going to install asbestos in it or on it or around it. So, for example, some of the things at issue are literally pipes, like overhead pipes in a corridor. And, of course, if they were insulated in some way, people were going to be burned, and the manufacturers knew they would be insulated with asbestos material at the time. Probably knew that it was dangerous at the time in some cases as well. But it was the bare metal that they sold, not the bare metal with the asbestos integrated. That's the question the court's really examining in the case.
So we have the asbestos manufacturer, we have the integrator, and now we have the bare metal provider. We're trying to reach deeper into the process, farther upstream.
Exactly.
Product liability is putting something into the stream of commerce, but I saw the word negligence used in both sets of arguments, so we're not using a strict products liability.
Correct.
We're using only a negligence theory, so all scrap does apply, as do several of these others. Okay.
And you are not the only one to struggle with that. The courts below struggle with the foreseeability question as well.
Circuits.
Also, again, from having worked on tech orders, which are kind of the instructions that how to use the equipment, it was also proved, the military does tell the contractors, they have to approve them. So I guess it depends if they have proof that they submitted ones with this warning, but the military struck it out, although 40 years later, I find it hard to believe anybody has records or anybody's still around from it. But if they were to have that or prove that they were stopped from giving this warning, that would be a consideration also.
Yeah, the allegation actually in the brief is that the Navy specified that the only warnings that should be placed there are warnings of risk of immediate harm, immediate injury. So, you can't work on something that's too hot, or this can harm you in this particular way, not risks like this of lengthy duration. So.
But I think it's very protected by following regulation. So that isn't sufficient by itself there.
Yep. Well, we do have another question on the chat, and that is, who's the real manufacturer? It sounds like the Navy's the real manufacturer if they specified the materials, and also even the signage for maintenance and the manuals and all the rest of that. And that really is the interesting question here. Isn't a ship just one big complex machine? And so can you then say that anybody who manufactured any component thereof would be in this chain of liability just because they did something that touched the ship? And that's part of what the court will likely struggle with is, what is the boundary on the respondent's argument that you have to warn if you knew? And go back to the battery example. Batteries for a flashlight that they keep on the bridge. Am I responsible for asbestos on the pipes and the bowels of the ship? Just how far do you go if you're involved with the overall project that is the complex machine that is the ship? And that's an issue that the court will most likely have to struggle with when it decides this case. And it's an issue that you have to struggle with when you decide this case. So it's time now to consider the first of our questions. Let me get our poll started so you can see it there. And I'll put it up on the screen in case anybody wasn't logged into the poll, anybody joined later or didn't get a chance to log into the poll. That's your first question to decide. And this is really the fundamental question in the case. Do we affirm the Third Circuit? Do we reverse them? Or do we reverse and remand for some additional proceedings of some kind? Go ahead and post your answer if you were able to log into our poll. And I'll share the results as they come in. We've got some background.
I got rid of it.
Nose going. Thank you. Appreciate it. Well, I hope that everybody can see at this point can see the results coming in. We have a decisive group. Nobody's going to remand. We're going to make the decision on this one. We have a little bit of a change. Looks like our, I don't know, is that happening because because I shared the results so people could still vote? Maybe not, I'm not sure. I think the percentage is just shifting as people complete their votes. Okay, finish up if you haven't voted yet. All right, we'll call it there on this question. And as everybody can see, about 71% of our court votes tonight indicated that they would reverse the Third Circuit, that they would say that summary judgment against these particular petitioners was more appropriate than the imposition of a duty to warn upon the sort of bare metal suppliers of these products. And you know, again, I would urge that after tonight's session, this is true of all of our cases tonight, that you'll keep an eye on this case. In most cases, these decisions won't come out until next year, so you have to kind of remember. But I hope you can remember where we ended up, and let's see where the court ends up on this particular one. All right, let's go back and take our next question. And this question goes to really what you're holding in terms of the law. So we've got one question that sort of is the affirm or reverse question, and then we have another question that goes more to the nuance of what we think the law ought to be going forward. Because after all, when the Supreme Court decides a case on a substantive ground, they really are deciding the law on a particular matter. So take a look at this one. I won't read this one out to you. And then post your answers. This one will take a little more time. By the way, I would emphasize you don't have to be intimately familiar with this law in order to answer questions like this. Hopefully we've given a little bit of the law that you need in order to be able to do it if you're not familiar with this area. But Supreme Court justices make decisions on a lot of bases, not just the law. So now is your turn in this particular case. So this time I'll wait until I think most of the votes are in. All right, I'm going to go ahead and share this because it's really interesting what the patterns we've been seeing. Until just a moment ago, nobody went for the bright line rule, which I found interesting. And now the bright line rule is gaining. There is a difference between these two sets of answers that you can see. And there's an argument among the parties as to whether there ought to be a bright line that says there is or is not a duty to warn, or it ought to be a question of foreseeability, facts of the case, and whether or not we would impose a duty based on the facts of the case. So many of our folks thought that this ought to be a fact-specific rule. 70% of us chose one of the two answers that are really fact-specific, either on the side of holding these manufacturers liable or not holding them liable under the particular facts as we've shared up to this point. And a few also think that we might be better off with a bright line rule that says these manufacturers would not be held liable. But nobody went for the bright line rule, said they would, which is interesting in the devolution of the case. Well, here again, the trick to this will be figuring out what happens when the court actually decides the case. Sometime next year, we'll be watching for what the court comes up with its decision in the Air and Liquid Systems Corporation versus DeVries case. Well, keeping an eye on our time, let's move to the next case on our docket. Let me call the next case for tonight, if I can. And this is the Dusky Gopher frog case. I'm sure that folks have read a little bit about this one or heard a little bit about this one. Let me put up our slide there. There is your, well, it's not actually a dusky gopher frog, but a dusky gopher frog looks a lot like this. I could not actually get a royalty-free picture of a dusky gopher frog that I could be confident wouldn't violate any copyright laws, but this is pretty much what they look like. The case, of course, concerns Weyerhaeuser, which has a long-term commitment to a piece of property called Unit 1. It's about 1,500 acres. I think it's in Mississippi. And it's privately held land on which they have contracted for the right to manage timber. And they grow a certain kind of pine tree there and actively manage that property as timber, renewable timber resource land. That property was, however, designated by the Fish and Wildlife Service as a critical habitat for a very, very endangered species of frog, the dusky gopher frog. Something like only 100 wild live gopher frogs exist, or existed at the time the designation process began, about 2001. And so the service looked around for areas that would be part of the critical habitat for conservation of the species in accord with the Endangered Species Act, the language of the Species Act, and designated this particular property. The landowners, of course, objected to that designation because it impacts the development opportunity for that piece of land. And it was estimated that the development opportunity for that piece of land is $34 million. So pretty sizable impact or taking of that land by government regulation, or the taking of that value of the use of that land by government regulation. And the argument, of course, was that the Fish and Wildlife Service has the power to pull something out of critical habitat if it can be established that the balancing of the biological benefit and the economic harm works out to favor the economic benefit of a particular piece of habitat. The service refused to do that. It has discretion at that point, and it exercised that discretion to conclude that this was critical habitat. So those are the basic facts that set up the complaints between the parties. The service's position, of course, is that it properly made the decision and can, in fact, stand on that decision. And the petitioners want to see that decision changed. Now, there are two issues in the case, and we're really only going to address this first one, just in the interest of time tonight. That's whether the Endangered Species Act prohibits designation of private land as unoccupied critical habitat, that if that land is presently neither habitat nor essential to species conservation. There's, of course, was a debate about whether it was essential or was not. The critical piece to know about Unit 1 is there are no dusky frogs there. There haven't been for a long time. And, of course, the property has one feature of what the frog needs to survive. At least at times, it has ponds. But it doesn't have most of the other features that are designated as critical species for the habitat. So, for example, it does not have a particular kind of forest cover. It does not have the kind of understory or ground cover that the frog needs. And all those things would have to be developed in order for this property to become habitat for this particular type of frog. All right, so that's our key question. There's no frogs there now. The property's been designated, and in fact would have to be changed substantially from its present state in order for it to actually be habitat for these frogs. And so the parties, of course, are arguing the limitations that are built into the law with regard to designating habitat under the Endangered Species Act. So the petitioner, which is Weyerhaeuser, says the service's power to limit to designate these things is limited. Congress commanded critical habitat shall not include the entire area which can be occupied by a species. And those limitations show that areas that can be occupied by a species mark the outer boundaries. In other words, it can't be occupied. So that's got to be the outer boundary, outside the outer boundary of the space that can be designated as critical habitat for the species. This property at present is not occupied and can't be by the species. Respondent, of course, again, this is oral argument. This oral argument took place on October 1st. The argument is, of course, the criticality of the actions of the Fish and Wildlife Service in respect to this species under its obligations to enforce the Endangered Species Act, and the propriety of the process that's essential to provide this habitat to discharge the agency's explicit statutory responsibilities. And therefore, it was properly designated as unoccupied critical habitat. That's the core arguments in the oral arguments presented by the petitioner and the respondent in the case. So let's take a look at the briefs for a second. And again, I'll just pause and let you read these. These are rather lengthy, and then we'll summarize. All right, now I want to tell you a little bit more about the arguments that are made than I could reasonably fit onto these parts of the slides. The petitioner's argument, of course, goes into the detail of the appropriate process of designation and what is necessary for this frog to survive and what would have to be done to the property in order for the species to actually survive on the property as it presently exists. It also argues that the petitioners have no responsibility to do those things. And so it would never be the case that that land, under this long-term contract for managing it as renewable forestry, would ever be in a condition that could actually accommodate a Dusky Gopher frog. Respondent, on the other hand, says the agency has a responsibility under the statute and exercise that in due course and with appropriate discretion. And you can only overturn that discretion if you are able to establish that it was arbitrary and capricious or some other very high standard for judging the behavior of a regulator following its statutory mandate to provide to protect the species area. Further, that the types of designations that are made definitely can include areas that are not presently occupied, so long as it is habitat for that particular species that has to be protected. Upon a determination by the Secretary, and that's where the abuse of discretion standard, the arbitrary and capricious test comes in to test whether the Secretary appropriately exercised that discretion or did not in the particular case. All right, well, that's a little bit more about the Dusky Gopher frog and the case. Let's talk about the legal issues and answer your questions about it. Let's bring it back to the room. Private land, not presently occupied, but has the potential, with some changes, to host the species. Interestingly, by the way, this is not a case that's going to be largely decided on the law. This is more policy questions. Any opinions, any thoughts, any questions?
Well, regardless of whether the dusky frog is going to live here or not, or ever in the future, the fact that warehousers prevented from using their land for this land, why doesn't the government just pay them and then they could take the land, change it, put as many dusky frogs, or we have other couple of crazy endangered species where I live, we could stick them all there and, you know, let the guy out of it. But, you know, stopping him from using the land in an unrealistic scenario that it's ever going to be used, it doesn't seem right. It sounds like a taking to me, but.
Yeah, and this invokes that question of whether the government can take private property either by actually taking it away or so restricting its uses that it can't be. What's interesting about this case is they're not actually as yet restricting the use of the land, right? In other words, they haven't stopped them from growing what they're growing. But they're not going to develop it. So they're taking away that future potential possibility of development. And that's what has the so-called $34 million value.
South Carolina Coastal, wasn't that a future development also? I'm trying to remember. Yeah, building lot. And the restriction that was placed on it was so much that it could no longer be a building lot. So it was a question of the extent of the taking. Was it enough to eliminate that large value?
That's right. And that becomes the question in the case because the Constitution prohibits the government from taking private land for public purposes without just compensation. That's the standard we have to apply.
But then the other half of this is a textualist argument. What's the plain language of the law and what does it mean on the petitioner's side? And I guess what are the obligations of the agency on the respondent's side?
That's right. And the respondent does have an obligation to designate habitat to protect this endangered species. That's the law.
Obligations.
Their arguments are strictly, we followed everything we're supposed to do. We did all the public comments. We gave multiple, in the brief, if you read the brief, you'll see over and over again, they talk about how they offered the opportunity for public input. And in the end, they disagreed with it. But they did everything they were supposed to do. Notice and comment rulemaking is the process, essentially. They put out a notice of rulemaking, and they took comment, and then they responded and made a decision.
Yeah, I was expecting a deference issue here, but petitioners said there is none. It's the plain language. They're arguing the text.
And actually, there is a deference question that's raised a little bit in respect to the second of the two issues in the case, Jim. If you look at it,
the economic analysis.
That's correct.
Yes.
I just want to...
That's a deference question that I expected to come before this court or the next year's court. It's been avoided previously with the Chevron and the Auer decisions.
But it's in front of this court, whether or not that is subject to judicial review. So if it is subject to judicial review, then if the court decides it is subject to judicial review, it should remand it for judicial review, right?
Yep.
Or decide it, because sometimes the court actually goes ahead and decides those things.
Good.
Any other questions about this one before we move to our decision-making mode on it? We have a question in the chat there about whether there's compensation provided by the federal government. Not in this case, not as yet. There's a designation attached to the property. Again, part of the debate is what is the economic harm that's been done by that? And the effort to this point has been to have the designation removed. That's been the complaint of Weyerhaeuser up to this point, because Weyerhaeuser intends to continue to manage it as forestry property. That's their objective. It is interesting, by the way, just to note that some 18 states wrote amicus briefs in the case, objecting to the action by the Fish and Wildlife Service on the ground that it imposes upon their latitude to decide land use questions within their state boundaries. So essentially, it's a 10th Amendment argument that says, under the 10th Amendment, of course, the powers not specifically granted to the federal government are reserved to the states. And so the argument here is that those powers to be able to regulate land use to this level were reserved to the states. There were 18 states that wrote briefs on that. There were also 13 additional amicus briefs in the case, most of those sounding in what you might expect about restrictions on development and the rights of businesses and that sort of stuff, Chamber of Commerce kind of stuff that were part of the arguments in the case. But there is this real question about how far the agency can really go in reaching out to designate habitat in this fashion, when in fact there's no frogs there, and there won't be unless something dramatic actually changes. Okay, no other questions about this one? Time to vote. We'll go to our first question, which, as before, is our question of the actual affirm or reverse. Let me get that up on the screen for you. And you should be able to go ahead and answer it in our poll. I think I'll let you see how this one goes because it's interesting. It's neck and neck. Oh, there, it was. If anybody hasn't voted, now is the time. Please make a decision. It looks like it's settled down. It looks like the majority of our group would actually reverse the Fifth Circuit and would say that the service acted incorrectly in designating this habitat. And some would reverse and remand. And when we do our next question, you might get a chance to examine that remand question. Anybody want to say what you'd remand it for at this point before we go to our next question?
The economic analysis is what
Okay.
I'm after.
Yep.
Yeah, I guess I said that, but mainly for, in this one case, we know there was hardly anything but one of many factors that would make the land habitable. But I'm sure there could be, you know, others that might be pointed out. So let the case go to, you know, let the case go to trial, and if the court can, or if the agency can show why this, you know, is a critical thing, then maybe they still can. So I guess just to have more facts.
So Frank, you would have them show their work on the science, which is an attack on the deference. Is that what I heard?
Right, well, both sides would be able to go back to the other court and show why their designation was correct, and, you know, have some weighted, you know, somebody's going to have to come up with weighted factors eventually, you know, because otherwise even the desert could house this frog if enough things were changed. So, you know, there's got to be somebody's got to lay down some rules for how far out the thing could be before they could do this critical designation.
Whoa. Okay. Let's see what happens.
I got a question about how to get into the poll from somebody. So I put that slide back up for everybody for just a second. That's the qualifier for tonight, to be able to log into the site. All right. You know what I can do? I think I can actually do this. Let's see if this works. Let me grab this. I'll put it right on the slide for our next. There's our next question. I'll paste that right in for everybody. So our next question, of course, goes to what you're holding. What do we take out of this? And I have given you another option here, because there's different ways you could think about this particular case.
That was harder.
It is harder. And actually, I'll share the results. Now we don't have everybody, but we have a significant number. I'll share the results, and you'll see it was harder.
The justices are going to take more time.
Well, it does bring up an interesting point about Supreme Court process, right? So we see the final votes, but there are interim rounds of conferencing and voting and discussion about these cases. And this is most likely the kind of case where there will be a fair amount of that. By the way, predictably, if you listen to the oral argument in the case, some of the questions that were asked and some of the comments that were made by the justices in the oral arguments. In particular, I think, Frank, your comment earlier about the number of factors and whether that should drive it was one of the questions of the court. Why not move it to trial? Sounds like a factual question that needs to be decided by a trial, as opposed to a decision on summary judgment. So it looks like most of our group would go with the land as being critical habitat, even if unoccupied, so long as that particular land is essential. And then we've got a significant group of other. So let's talk about the other for just a second. What kind of other thoughts did we have?
Yeah, the two people made that vote. What type of other?
Anybody want to share?
Well, I think it's still going back to the economic analysis. And if the country finds that this is an important resource that's worth saving, that we work collaboratively with the property owner to make it, a potential habitat. But I find it's just a slippery slope as to how far you go to protect species X. And, I have an environmental science background, so I'm maybe more sensitive to this than other people, but I think at some point you have to draw a line. But if it's a collaboration and if this is found to be of critical importance. And the other thing I find interesting is this a court, a question that should be answered in a court of law? I mean, I think if the Fish and Wildlife Service sort of has this carte blanche and they could take it and run with it, and there's no sort of bridle to it, does it go back to Congress to write the regs again? But I mean, I find it maybe an odd place to be having this conversation in a courtroom, but I guess that's where it ends up.
Yeah, and that's the challenge. It ends up there because there's nowhere else to go with it, except, of course, the lobbying will be going on. You can bet that Weyerhaeuser has lobbyists and working the issue for Congress to change the statute on this. And so it'll be very interesting to see how it evolves, no matter how the case turns out on this particular topic, because there are, as you say, other forums where the decision might be made. Sounds like, James, you might be your other is a vote for perhaps a more nuanced rule than the three that I've offered here. And that seems like a pretty reasonable vote to me. That we might need something a little bit more nuanced for this particular difficult circumstance. Okay. Anything else on this one? Let's keep going. We've got one more, and it's one that I think touches everybody, and you'll want to know about. Okay. Let's go on and go back and speak to our Apple case. This, of course, concerns the App Store. There's your iPhone, there's your App Store button right there, and all that stuff around it. That's what this case is all about. Let's see, are you seeing the PowerPoint? Okay, everybody? Thumbs up if you are. Okay, just checking. A little weird indication there. All right, so this one, of course, is an antitrust case. And we know that whenever you have a monopoly situation, you have the risk of antitrust. Now, of course, it's not a monopoly on cell phones. There's lots of competitors for the sale of the phones. But in a closed architecture system of the sort that Apple maintains, well, these plaintiffs creatively argue that, in essence, that's a monopoly, because nobody else, without the approval of Apple, is able to actually put anything into their system. So the facts, of course, is this was a putative class. So it was an attempt at a class action, and claiming that Apple monopolized the market for iPhone applications. Note that any market can be identified, and we can talk about monopoly players in a particular market. And that because of the control they exercise over iOS, that they are able to then charge what these plaintiffs consider an excessive commission, 30%, on all those apps that are actually paid for apps. And Apple's defense and Apple's argument, of course, is, well, we don't set the prices. We just require a certain commission on sales. The developers set the prices. So we don't control the market because we only control the platform and the percentage of commission. So the case, the court accepted the case on the question of whether consumers can sue for antitrust damages to sue anyone who delivers them goods, even where the damages that they're seeking are based on prices set by third parties who would actually be the immediate victims of the alleged offense. In other words, it's the developers who would actually suffer at the hands of Apple's monopolistic action, or it potentially is. And that's the question we're examining. Can consumers sue in that situation where it's really a third party? They're really almost a third party to the essential transaction of the marketplace. Now, you don't have to know very much about antitrust law to understand monopolies, but you do need to know a little bit about this question of the overcharging and the pass-through expenses. So this case called Illinois Brick, and the case essentially said that only immediate victims can complain about anti-competitive conduct. So only direct purchasers, not downstream parties, third parties, and folks who have damages through some kind of pass-through. And if you think about the typical case where we're selling, a good, we sell it and then somebody adds on a markup and somebody adds on a markup before they sell it further along. Illinois Brick and cases like that were designed to address those parties who were distant from the initial transaction with the monopolist and prevent them from being able to make their complaints. We're really awarding these kinds of overcharging damages, particularly this claim of overcharging with respect to the 30% commission, to the initial participant in the market. And of course, Apple says that Illinois Brick applies, and Illinois Brick should prevent us from being responsible for this antitrust, because again, the people who would be harmed here are really the developers. They're not. It's not the consumer. Now, I would note that Apple's concern here, of course, is the millions and millions and millions of consumers with potential claims if they lose this case. They would rather deal with the 80,000 developers, and if they have to do something, they would do it there, much preferably to the millions upon millions of consumer customers. Then, of course, the respondent, on the respondent side, is, we don't have, by the way, oral arguments in this case, so I'm giving you a little bit extra from the briefs here. Their argument, of course, is that there's no market except from Apple in the App Store, because Apple makes sure there's no such thing. There is no third-party market in any fashion except to buy them from this store that is run by this monopolist. And so that changes the picture in the consumer's view completely. And essentially, the consumer is, in fact, buying direct from Apple because Apple facilitates the transaction. So there is question about whether these particular complainants would be appropriate plaintiffs. In a sense, it's a standing sort of question, whether they have standing to bring this claim based on Illinois Brick. And of course, what's interesting about it is they might be developers themselves as well as purchasers of apps, because the consumer argument goes to literally anybody who ever purchased an app from the App Store. So if any of these plaintiffs ever bought an app, they would be appropriate plaintiffs on one side of the claim if they were developers complaining on the other side of the claim. And it's pretty likely that a developer bought an app somewhere along the way. So, of course, there are no, the argument, of course, there's no real competitors. The respondents have to pay prices in a monopolistic market. And their complaint, of course, is that they shouldn't have to do that. Okay. Now, there were some further arguments that I'll share with you about this. Won't spend too much time on them. Just take a second and read them. Particularly, I think you'll find the Apple or the respondent arguments more interesting. I think the petitioner arguments are a bit more of the same. Well, actually, I guess I already summarized most of those respondent arguments as well. So let's bring it back to the room for questions, discussion, comments. This case that potentially affects all of us. Almost all of us own a smartphone from one of two manufacturers, 2 or 3, and they all have app stores. You might also note, by the way, that Microsoft has moved in this same direction in respect to its core products, that you want an app to install on your PC, you now are expected to go get it from the Microsoft store. So this case has wide-ranging implications. Let's just put it that way. Questions, comments?
Reminded a bit of the days when you had to buy your telephone from the Bell.
And that argument was analogized in the briefs, as a matter of fact.
Yeah. It just sounds too much like that to me, and not like Illinois Brick. I did a quick look at a summary of that case, where the government was trying to sue on behalf of consumers, and the actual users of the bricks were the builders upstream. The consumers are not as downstream here as they were in that case.
So, in fact, Apple handles the payments processing and the whole shebang, doesn't it?
Pretty much. Sounds
Pretty
like
much.
Well, it really sounds like they should reverse that other case anyway, because it sounds like the consumer is going to pay in the end, regardless of who upstream doesn't object to it. So in that case, the builders could buy bricks at 4 times as much as really they should be, but it doesn't really matter because the guy buying the house ends up paying for it. So I'm not sure how they came down on that, not having studied that case. But
well, it was the usual sort of floodgates of litigation argument, right? It was we've got to draw a line someplace because products move around in commerce and people way down the stream disconnected from the transaction might be affected. We don't want them to have those claims. So it was that type of argument, Frank, that they made.
Yeah, but here the developers are also sellers. They're not buying something from Apple and then passing it on to a consumer. They are giving something to Apple that Apple's passing on to a consumer. So it doesn't seem an analogous case to me.
Yeah. Yeah, in a sense, they seem like manufacturers, don't they? Paying a manufacturer's rep to sell their product.
Mm-hmm.
That's kind of the circumstances. Okay.
Apple doesn't have, I mean, to my knowledge, Apple doesn't have overwhelming market share in the smartphone market. So if they're the supplier,
yep,
and then the apps developers are the sub-suppliers behind Apple,
yep,
then I don't know from a market share point of view, you can make the argument that Apple is monopolistic. And because you have a choice to buy somebody else, anybody's phone you want. You don't have to buy an Apple.
No question. Yeah, and what's interesting about this is the way that the case defined the market, right? It defined the market as the market for apps to be sold to people who have these phones. And so it's a narrow, much, as you say, Brian, a much narrower definition than the smartphone market or the market for applications generally. It's a very narrowly defined claim by these plaintiffs that Apple's monopolizing this very, it's still, I assume it's billions of dollars, right? It's not a small market. It's just a narrow definition of that market. You're absolutely right. That's what makes these things interesting. Is can you bring an antitrust claim about something that confined? Well, it went all the way to the Supreme Court, so you can get that far anyway. We know that. All right. Well, time to vote. You can go and take a look at the questions on the other side. I'll bring them up back here. Once again, we start with our Affirm reverse question. You might want to read this one because it does lay out sort of the exact procedural posture.
I'm assuming Apple also claims by controlling the App Store, they provide other values such as security for their customers.
They do. That was definitely part of their defense. Yep. And their reasoning behind why they control it the way they do. No votes yet. A couple of votes coming in.
We're neck and neck. Oh, just pulled ahead.
Yeah, one of the challenges of putting it up, of course, is that it might influence people's votes, which is why we don't get to see votes in real time in political elections.
I was about to vote to remand, but I couldn't think of what the remand question would be.
And you knew I might ask you. That's the problem. It's really a question of whether they can certify this class or not. Whether or not these plaintiffs can get past this. Motion to dismiss.
If we're only certifying the class, then I'm even more emphatic in my choice.
Well, that's more or less. I mean, that's why I said read the procedural posture stuff, because this is really just an appeal from a decision to dismiss the putative class action. And that was reversed by the Ninth Circuit. And now Apple, of course, is trying to get it dismissed again, but that's the question. And as you probably know, once you get a class, once you can certify a class, you largely won the case because of the amount of money it'll cost to fight it. at least depending on the particular case, because you've done so much of the background to get to the point where the class gets certified. They almost always go into settlement negotiations at that point.
You'll win a coupon for 5 free apps.
And that's what it'll be. That will most likely be your outcome. Okay, well, it looks like that's probably most everybody who's planning to vote on this particular one. And it is indeed a difficult one to know. Most folks would let the case go forward, and I don't know if we're voting as consumers or we're voting based on antitrust policy on that one, but maybe both, because it could be both in that particular circumstance. Let's go on to our next and last question of the night. This, again, will take a little bit of time. It's some complicated holdings for you to parse out, but they're in groupings. Take a minute to look them over. I will say they are structured in a way that you'll see some patterns in an effort to make it a little bit easier.
As far as I know, there's a price for selling the app, and within the app itself, you can actually spend more money.
Not unusual for that to be the case. That's right.
So somebody can sell the app for free, as it were, and all the money is made later.
That's correct. That's possible. So you have all three models. You have free apps that have no opportunity to buy in-app purchases.
Miranda has left the meeting.
Have or do not have that opportunity in this marketplace. All right, well, let's swing over and take a look at our results. No results yet.
Oh, I don't see a poll.
Did the poll question not appear for you?
I see the choices, but not the poll.
Oh, I can show you the results. Nobody's voted yet. Oh, there's one.
Oh, I'm sorry.
I'll give everybody just another second if anybody hasn't voted yet. Okay. Well, let's call it there with respect to this one. A little change right at the end. Looks like the majority would find that Apple monopolized the market and, in fact, exercised pricing control power. There were some other facts in the case about Apple requiring prices to be set at precise dollar increments, $1.99, $2.99, $3.99, and so on, so that a developer did not actually have the ability to independently set all aspects of the price in these distribution agreements they had with developers. So the case is really very interesting, and of course this one hasn't been argued yet. So I would urge everybody to take the opportunity to listen to the argument, either, well, you usually can't listen to it live, but listen to it afterwards, and take a look and see if the thoughts that you had as you were examining the case are similar to the arguments that were made by the lawyers who were presenting it to the justices, or your questions were similar to the questions the justices had about these areas. And that, in fact, of course, is what's fun about taking a look at the cases in the court. You know, whoever's on the court, we have a set of personalities and a set of objectives that we can kind of pay attention to and handicap. But when it all comes down to it, we have to make decisions based on the law and where we think the policy should be. And I would say that based on what I saw tonight, that probably most all of you are just about as qualified as anybody on the court to make the policy decisions anyway, because they do affect us much more so sometimes than the pure legal things. Look for decisions on these, of course, sometime in 2019. That would be the typical timing after they get through the process. And I want to say thanks for joining us, for being a part of this session tonight. We appreciate you serving on our court panel for this evening's session. And we at St. Francis appreciate your attending our event. If you're one of our students, one of our prospective students, we appreciate that as well. It's been a very great pleasure working with you. We'll call it here. Have a great night, and thanks for sticking with me and for engaging and talking about some important cases. Thanks, everybody, and have a great night.
Thanks. This is great.
Thank you.
Right.
Thank you. Good night. This is great.
Has left the meeting.
Rebel resident.
Has left the meeting.
Thank you. Bye.
So long. Thank you.